there are other ways in which the employer can also be held responsible for damages due to its failure to administer the benefit plan properly. For example, there was one case in which the individual had life insurance and his employment was terminated, and he was not told that he had the right to convert it into a privately paid plan of life insurance. So he didn't know not only of the right of conversion, he didn't know there was a life insurance policy. And the court found that that was a negligence on the part of the employer, and the employer had to pay for the death benefit as the person had passed away. In another case, the employer had told the insurance company that the employee in question was no longer employed by it, so the insurance company took it off the insurance coverage, and he was still working. So again, there was a negligence claim against the employer that succeeded. In yet another case, an employee was suffering from cystic fibrosis when he applied to the company for employment and was concerned about his disability coverage, quite naturally. And the employer said, well, as long as you come to work for 90 days without being absent for any medical reason, you'll have disability coverage. Well, that was not the case. In fact, the individual had to pass medical underwriting. So he passed the 90 days, thought he was insured, and then found out he wasn't, suffered a medical disability, and the employer had to compensate the individual for the loss of the disability insurance, which in that case was about $83,000 plus 10,000 aggravated damages. So the point of all this is that the employer has an obligation to be careful in the administration of the benefits plan. And if it does not live up to that obligation, it can be sued for negligence for not adhering to that obligation properly.